both wills and trusts will transfer your assets, but they're going to do so in completely different ways. And we're going to go over the real difference between them, and we're going to make it simplified. In today's video, I'm going to break down what each one does, how they're different, and which one might make the most sense for you. I'm Darcel. I'm an estate planning attorney in the Seattle area. If you're local to the area, I'm in Normandy Park, specifically kind of close to SeaTac Airport. I've been a licensed attorney for over 16 years. And let's get into estate planning and wills and trusts, and let's just demystify them and help you decide what's better for you. Because before we get into the details of it, I want to make sure it's clear that both these options can be great options for most of you. Now, wills versus trusts, they do work differently, but they both work. One is not bad, one is not better than the other. For different clients, a will may be a better fit. For other clients, a trust may be a better fit. And the end result of a will or a trust, we can reach the same goals. Like the end result can be the same. It's just a matter of how are we going to get there? Which vehicle do you want to use to administer your estate? So I wanted to start with that because sometimes there could be a notion of, a will is bad or a trust is bad. And, different states have different laws. And so in different states, sometimes people do view a trust as more preferable or a will as more preferable. But in Washington state, I don't think that's as true. Probate here is more simplified, it's more streamlined. But let's kind of get into both options so you can decide what's best for you. We're going to start by talking about what is a will. Before we can kind of really compare the pros and cons or a will versus trust, I need to make sure that you understand what a will is and how it works. So a will is going to outline who receives your estate after you've passed away. However, in order for it to take effect, in order for that to actually happen and for your assets to get to your heirs, it has to go through probate. So you'll think of a will as like a set of instructions of what you want to have happen, what the plan is, what the blueprint is for your estate. But in order for it to actually happen, it has to go through a probate, where a probate court and a judge will oversee the administration of your estate according to the terms of your will. So upon your passing, the will gets filed with the court, probate gets opened, your executor is appointed, letters testamentary are issued, and the person that you have named can then go forward, liquidate assets, pay any debts that you have, take care of your final tax returns, and then ultimately make distributions to your heirs. There may be real estate to be sold, vehicles to be sold, things of that nature, and they're able to handle all of that, but through the oversight of a probate court. And at the end of the probate, then the executor is filing a final declaration of completion, itemizing what the assets were, what the debts were, and who received what. So that is what happens with a will. It goes through probate. So let's compare that with a revocable living trust. A revocable living trust is different than a will in that it holds property during your lifetime. So when you create your revocable living trust, the step 2 of creating your trust is putting your assets actually into the trust for the trust to control. During your lifetime, you control the trust, you control the assets, you manage it. Whatever you wanted to do with your property, you want to buy more real estate, you want to sell real estate, you want to rent out real estate, you want to have investments. You can do all those things, but you do so through your trust. And the reason you do it this way is that upon your passing, your successor trustee can then proceed to liquidate assets, pay debts, file your taxes, and make distributions to heirs, but they do so without probate. That is the biggest difference between a will and a revocable living trust. Again, the end result of your estate going to your heirs, that's going to happen in either scenario. Just how are we going to get there? Are we going to get there through probate with a will? Or are we going to get there without probate through a trust? That's the biggest difference. So really I usually see 3 reasons why a client would want a trust over a will if you're trying to decide between the two. One is avoiding probate, right? They don't want their family or heirs having to go through a legal procedure, having to go to court, having to just go through that probate process. Also, second reason, and also is along these same lines, is that they want more privacy. The will and probate are all public record. Anyone could look up the court records and see what your will said, look at the probate, see what your assets were, see what the debts were, see how much your heirs received. That's all public record. With the trust, it's not public record. It's not filed with the court. It's not probate. It's not as public as a will is, so the trust gives you more privacy. And then if you have real estate outside of the state, so let's say you reside here in Washington, but you also have a second home. Usually Arizona is pretty popular for clients. Hawaii is another one. So let's say you have real estate in another state. The trust may make more sense for you because otherwise there'd be a probate here in Washington, but then also in the other state where you have your other property. So if you have real estate here in Washington and Arizona, you could be looking at 2 probates for your estate, one in Washington state and a second one in Arizona state for that real estate down there. Those are kind of the key reasons as to why I see a client look at a trust over a will. But again, the end result is the same. We can get to the same distributions. It's just how are we going to get there? So which one is right for you? Is a will better for you? Is a trust better for you? So with the will is simpler. The will is more affordable up front. So a will-based estate plan is less expensive than a trust-based plan. The trust has a little bit more to it. It's more complex. There's more drafting involved, so the trust is more expensive. However, with the will option, there will be a probate on the back end upon your passing, right? So when you factor in the will plus the cost of that future probate, that's going to exceed the cost of the trust. And with the trust, again, you're not going to have probate later. So the trust will ultimately be less expensive, but for your initial upfront investment to get your estate plan done, the will is less expensive. And that is a factor, right? As far as the cost of what it is to get your estate plan done. So the will is going to be less, the trust is going to be more for that initial investment into getting your estate plan done. And then also with the trust, there's not a lot of management that you have to do, but you do have to make sure that once we create the trust, and here at our office at Dow Law Firm, we help you with funding it, we get your real estate into it, we take care of that for you. But going forward, if you acquire future real estate, you have to make sure that that future real estate gets into your trust, because the trust has to own the asset in order for it to control it upon your passing. And then so that's what the will option looks like. For a trust option, if you're not sure if that's right for you, if you have real estate in more than one state, the trust might be a better option for you. If you want more privacy, if you don't want everyone seeing what your estate included, what your assets were, what your debts were, and how much your heirs received, trust might be a better option for you. If you don't want your family to have to go through probate and that court process and those proceedings, then again, a trust could be better for you. So whether you choose a will or a trust for your estate plan, the most important thing is to just have a plan in place. I tell my clients all the time, that's one of the best gifts you can leave to your family upon your passing, is to have a comprehensive estate plan where everything's laid out, you've made all the decisions, everything's outlined for them to just follow. And for a lot of our clients, getting their estate planning done has been on their to-do list for years. For some clients, it's been many years, right? It's been 10 years, 20 years. I have clients where they come in and they'll say, when our kids were born, we wanted to get our estate plan done, and we just never did. And now they're adults. Our kids are grown, and we need to get our estate plan done. And that's okay. We are here to help you get it done. So let's get your estate plan done off of your to-do list, whether you want to do a will, if you want to do a trust, or if you're unsure. During our consultation, we'll go over kind of what your wishes are, what do you want. We'll kind of go in detail about the pros and cons of each and help you make that decision. My goal as your estate planning attorney is to make it simpler for you, easier for you to understand, not so overwhelming, because I understand that nobody wants to come in and talk to an attorney that they don't know about what's going to happen when they've passed away. That's not a desirable conversation to have. I fully understand that. We don't, it's natural to not to want to have those conversations, especially with a stranger, right? And sometimes I'm asking questions that maybe things that you haven't thought about before, especially if you have children who are minors, something happens to you, what's going to happen for them? Who's going to be their guardian? Who's going to take care of them and their inheritance, right? These are all questions that might not be the most comfortable to discuss, but they're important conversations for us to have. And so whatever I can do to make it easier for you, we do. And so we offer consultations in person, over Zoom, by phone. We do a lot of things electronically to kind of help make things easier for you when it comes to signing. We take care of all that for you. We prepare a binder for you that has all of your documents, instructions for your family, important resources and information. We do what we can to make it easier for you and your family. Usually the hardest first step is like making that call and having the consultation. Because again, I understand it's uncomfortable, but it's one that's really important that we have. We need to have that conversation. We need to make these decisions and put it in writing and have it signed so you can know that if something were to happen to you, there's a plan in place and it's all taken care of. So if you need help, contact our office. We'll be happy to help you. Our number is 206-408-8158, and I'll see you in the next video. Thanks.